Hello and welcome to Color Me Healthy, wonderful workshop today on something that many of you have asked for. So welcome to our online audience as well. I want to do a quick introduction of our speaker because she's never been to us before. So meet Andrea Jacob. Okay, so she's been practicing law for 31 years. I really don't believe it. She doesn't look old enough. I love what she says about how she's developed a unique and personalized professional approach to working with clients. She has her Bachelor of Science degree in Business Administration from Boston University and her law degree from the University of Miami. Yahoo, go you. She opened Andrea L. Jacob, PA in 2007 and has been practicing in the areas of wills, trusts, and estate, probate, elder law, and business law. She often speaks at the Broward County Library on estate planning and probate topics. She also is taught as an adjunct professor at Miami-Dade College and at City College. So she's always teaching about a subject she's very passionate about. Her legal team is a robust group of attorneys and staff that take a great deal of pride in making every person that walks through the door feel like they're in a home and feel comfortable and not just as in a law office. And I love that about her. And she was just telling us that she makes sure her staff is well fed. So we are kindred spirits in that because we want to make sure that our teammates are also fed. She's been married for over 25 years, again, hard to believe, and has raised two wonderful children. One of the things that's real important today is that you will have an opportunity to ask questions at the end, but these cannot be about your personal circumstances. These need to be general questions so Andrea can address it to all. We can't get into your personal situations at this time. So I'll turn it over to you, Andrea. Take it away.
Thank you so much. First of all, I'm so impressed with this turnout and with this program. Kim, thank you. This Color Me Healthy program that's provided is really very impressive, and I'm looking forward to teaching you all a little bit about what to avoid and some mistakes that people make, some celebrities and the mistakes that they've made. We like to use them as examples, and I'll get started. So we'll talk about what is an estate plan, what is probate, celebrity probate horror stories, and how to avoid your own probate nightmare. So an estate plan is not just what happens when you are done with your life. It's what happens during your lifetime if you have a short-term illness or a disability, and how we age in a way that we keep our autonomy, that the people that we want to make decisions for us make those decisions, and we don't have anyone from the county stepping in to take control of our lives. So a little transition there. So during our lives, sometimes we deal with capacity planning, loss of capacity. Does anyone have an elderly parent or grandparent that may go through some dementia? And it's really scary. And so we talk about how to make sure that you have the plan in place to make sure that you've got control. Healthcare directives, end-of-life decisions, long-term care, and sort of everything else. So we're going to start with healthcare documents. People don't realize that you need some healthcare documents in order to have the ability to have communication on your behalf. So what we look for is to see who is the person in our lives or the people that will make the best decisions for us if we have a healthcare emergency. My daughter's probably watching on Zoom. I always use her as an example, but her freshman year in college, she broke her jaw. And of course, when I called the hospital, the emergency room up in Tallahassee, the nurse said, "Well, ma'am, I can't speak to you." And I said, "Please check your fax machine," because I had already sent to her the necessary healthcare documents so I could speak on my daughter's behalf. Of course, an adult is 18 and older, but the next day she could speak on her own and I was no longer allowed to speak for her. So you have to make sure that you have the ability to speak for your loved ones and the right people speak for you. So designation of healthcare surrogate, who's the one that the hospital will speak to. We also have a living will. That would be a document that we worry about being kept on life support past our expiration date. And it's really a release of liability of a hospital, because without a living will, they will not remove life support without a court order or an ethics committee. You've, I'm sure, heard stories in the past and TV shows with people kept on life support for longer than their family may have wanted. A living will is not a DNR. you all are eating lunch. So if you have a problem with pictures that may be a little icky, close your eyes for a second, because I'm going to show you what a DNR looks like and what it doesn't look like. So that's a DNR. It's on a canary yellow piece of paper. Do not resuscitate tattooed on your chest does not work. This person was resuscitated in Miami-Dade, and that's actually the picture of their do not resuscitate. So, okay, you can open your eyes again. Those are the healthcare documents. Any questions before I move on? Okay, powers of attorney. Yes. It's not a DNR. A DNR is on that canary yellow piece of paper. It's a do not resuscitate order that's specific to the institution. A living will is a general, if these situations are occurring, I do not want to be kept on life support and take longer to pass away.
How about a directive?
Well, these are directives. So these are all part of the healthcare directives. But in Florida, we have some very specific statutory provisions, so we call them by different words. So a durable financial power of attorney. One more, yes.
It's not always yellow, though.
Different
states have different colors.
Correct. In Florida, it's yellow, canary yellow. Other states, I can only tell you about Florida. I used to practice in Maryland, but that is now inactive. So I'm only in Florida now. A durable financial power of attorney, I think, is the most important document that anyone needs during your lifetime. If you're all here working and someone's at your house and your cable goes out and they call to have the cable put back on, or they're complaining about something and they say, well, I can't speak to you. I need to speak to the person who is on the account, right? And then you have to get on the phone and say, yes, I authorize them to speak for me, whatever it's cable or insurance. A durable financial power of attorney gives the authority to a loved one to speak on your behalf from the get-go, so that you can say, oh, no, I'm not there to speak about my insurance, but my power of attorney is on file and you can speak to my spouse at any time or whomever it may be. So it avoids a guardianship. We do a pre-need guardianship. A guardianship is kind of icky. That's where somebody may be appointed to take over your financial affairs, even temporarily. You don't want somebody appointed from the county to take over. So we do a pre-need guardianship. Wills and trusts. Without a will, you have an intestate estate. That means the law, and each state is different, but Florida law, I'm going to show you in a moment what it looks like. But let's say you're married to someone for a number of years, but then you split up and then you're living with someone who becomes your partner for the next 20, 30 years. If you pass away without a will, it could be that spouse that you used to have that will get everything and not the person that you've been loving for the remainder of your life. And that is a problem. So you don't want your property to go to the wrong people in your lives. Somebody asked me when we first got here today, I'm not going to point anyone out, but if you try to do your own will by using an online form, please don't, because we have a robust probate department at my firm. And unfortunately, a lot of those are people who had tried to do their own wills or left things out and made some mistakes. So we don't want you to create a mistake. Those do-it-yourself wills are not Florida specific. They're not specific to your needs. And quite often they're done with a lot of errors and legal fees. Anyone ever have a probate case that has taken over a year to deal with? Right? So we want to avoid that, right? For when you lose someone that you love, you don't want the added insult of spending another year and all your money trying to get your home. You had a question?
Yeah. On any of these that you're speaking about, the ones that you can do yourself, that make sense, like your own healthcare surrogate or something like that. Can you let us know which ones of those?
Your healthcare surrogate and a living will you can do yourself, as long as they are the Florida statutory ones. Yes.
So you can safely do those without.
You can. Of course, if you want to scan it over to me. I'll review it for you. In fact, everyone from Team Horner, if you let me know, we will give a discount and some assistance for you all from coming today. So, but that is definitely, I rather you do things right, right? So, but look, I could try to build a pool in my backyard by digging, but I know it's going to like end up in a big muddy mess. So if you don't do your wills yourself because you want someone who knows what they're doing to go in and take care of it without making that mess. So Florida law requires a notary and 2 witnesses for each will. And there has to be also an affidavit attached. So there are quite a few requirements that aren't known or frequently known by many people. So you want to make sure that if you do use some sort of online form or an attorney that charges you $100 to do the whole thing, which is probably a brand new attorney, doesn't know what they're doing, you're not going to have things executed appropriately. Executed, I mean signed, not executed. So let me talk about trust agreements. So a trust is an entity that you create that can hold property on your behalf. There are 12 different types of trusts. Quite often we talk about what's called a revocable living trust, which is just an extension of yourselves. No tax return, it's your own social security number. It just enables you to hold assets to direct how they will pass following your passing. So these are different types of trusts: revocable trusts, irrevocable trusts, joint trusts, land trusts, pet trusts. We love doing pet trusts. I love my dog and I would want him taken care of. So we see a bunch of different scenarios in our office because every family is different. Every person is unique, but there's some standard scenarios that we see sometimes. So married couple in their mid 40s, with their home and some bank accounts, there may be put together 400, 500,000 in assets. And what documents do they need to plan for the future, right? Have they figured out who would be a guardian for a minor child? If you have a minor child and do not have a will in place that names who the guardian would be, you may want to check on that because you don't want the grandparents or aunts and uncles fighting over who would be the guardian of that minor child. You want to appoint the person that you would wish would be there. And so we also want to see, is everyone healthy? Does someone have a special needs? Do one of the children have autism and we're concerned about them being able to work and provide for themselves as they grow older? So we look at every different circumstance and we talk about in detail every member of your family and how to best protect them. And how are the assets held? A blended family, Brady Bunch, right? I'd say the majority of our clients have stepchildren, stepbrothers, and some sort of relationship that is not the, Beaver Cleaver family. And we sort of want to protect a blended family differently than what you had seen on TV many, many years ago. So what we don't want are Greg and Peter and Bobby to inherit, instead of Marcia and Jan and Cindy, their mom's assets, which could happen if you don't have things in place. Someone who is a widow or widower, where they may have quite a bit of money in their name, and what do their lives and relationships currently look like? Our parents, when they age, they can start getting into some trouble in some ways, and we worry about those financial predators that don't look like predators. They could look like a new relationship, but when it comes to the end, it could be a financial predator. So are there any grandchildren, or who is going to look after her if she's in an accident or has an emergency? So, but those are just different scenarios. every family is different, and we sort of just want to make sure that we learn enough about you and your family to understand and to tell you what would be needed that you may not even realize. And then there's long-term care, which is kind of scary because you don't really think about what will happen if you do have a long-term disability. But long-term care, you can take care of yourself, have a family caregiver, home health care, but you may need independent living or assisted living or to be in a nursing facility. And how are you going to pay for that? Private pay, do you go into your own assets? Do you have family that can help you? But we also look to see what sort of disability programs that you may be entitled to, veterans benefits, Medicaid benefits, and what way we can afford to have the care that we need as we age. My clients don't like to think about this, but we like to sort of put it out there so you have an idea of what you may need to know in the future. So let's go to our next part of the agenda and talk about probate. Probate is the process of a judge reading your will. It's a Dear Judge letter, reading your will and deciding what creditors must be paid and how the assets are distributed. And it can be long. If you own an asset and you pass away and you're the only owner of your asset, like your home, you pass away, that home is now a probate asset. We're going to talk about how to avoid probate toward the end, but probate would be required if there's no beneficiary listed on an asset. And it is, many people believe a will avoids probate. It doesn't. A will is not dispositive of your wishes. You cannot walk into a bank with a copy of a will and say, this bank account goes to me. It doesn't work that way, right? That will has to go through probate to determine where the accounts go. So this is why a do-it-yourself solution sometimes is really scary. So in probate, disputes are resolved. There's always a dispute because somebody got the ring that somebody else wanted, or the book, or the lawnmower we've had. And families can sort of, sometimes the fight to them is more important than the actual item. And you don't want your family to fight. So the goal is family harmony, right? If you pass, you want your kids to get along. You don't want them to fight over silly things. We deal with creditors, having to pay creditors, and somebody is appointed as a personal representative. In other states, they're called executors. Here in Florida, they're called personal representatives. And then we distribute the assets according to what the will states, if there's any money left, when the judge signs their order. So probate is public. Now, you don't have access to all sorts of probate cases that there may be filed with the court, but your will is recorded after you pass. Your will is public to those people in your family. It's public, while a trust is private. So any information in your will be known to your family members. So let's say there's one child or cousin or someone that you just don't want to get a thing, and you say it in your will, they will know. If you say it in some other way, they will not know. And it's time consuming. It could be about 3% of all the assets in your entire estate that would go to this probate attorney that your family would have to hire. Not in my case, but so if you do not have a valid will, it's called an intestate estate. And this is what it looks like in Florida. People say, well, who would things go to? This is a little complicated because it depends upon whether there's a blended family or not, and how many children there may be, and where things would go. So that is what things look like without having it stated in a will. So let's continue a little bit and talk about what do Picasso, Jimi Hendrix, Abraham Lincoln, Michael Jackson, Kurt Cobain, Amy Winehouse, Bob Marley, Stan Lee, Bob Saget, Norm Macdonald, and Sonny Bono all have in common. Anyone know?
They didn't have a will.
Right, exactly. Bingo. They died with intestate estates. So without having a will. So let's talk about a couple of the examples of what can happen if you pass away without having a will. Howard Hughes. He had $2.5 billion in the 70s when he passed away. That's a lot of money in today's numbers. He had no will. So who do you think ended up with his assets? His attorneys, right? Because this was a decade of fighting, and the attorneys got paid on an hourly basis. And they ended up with a large portion of those funds. So it was a problem, and you don't want the attorneys to make your money. So Prince, I loved Prince. He did not have a will. Unfortunately, he was surrounded by agents and managers and business promoters, but he didn't like lawyers, and he just decided that he was never going to die, right? He didn't realize he was going to overdose at 57, I think, and he didn't have a will. So what happened was he had a full sister and a bunch of other half siblings and people who claimed that they were relatives who all came forward. Guess who made out in this case? The IRS. In this case, the IRS made out because when they put together all the assets in his estate, he had like $140 some million, and that was tax. Anyone know what estate tax is in this year? If you pass away with how much money does your family get taxed? Anyone know? $12.092 million per person this year. So if you have 13 million, you're in trouble. Or 26 million for a couple. Now that's going down to about 5 or 6 million in a couple years, but it's still a pretty high bar before we pay estate taxes. So unfortunately, he or his family, whoever ended up receiving money, didn't end up with what they, no, 5 million. Yeah. Hey, listen, you never know. I think the Powerball is up to 175 or 700 million or something. There you go. We know. Okay. So Anna Nicole Smith, she married someone only 62 years older than her, but she was not going for his money, right? No. But he verbally promised her half of his estate. So his son, of course, after he passed, the son, I have to get this right because it's E. Pierce Marshall, I believe, was the son that fought Anna Nicole on the estate. Then, so Anna Nicole and the other son, J. Marshall, teamed up together to fight E. Pierce Marshall. Then E. Pierce Marshall died. Then she had a daughter, Daniel Lynn. Then 3 days later, her son died. Then she died. So there was a period of time where there was a baby billionaire named Daniel Lynn. And a bunch of men came out saying that they were all her father. Turned out we found out who the father was, Larry Burkhead. And then we found out that Daniel Lynn wasn't getting those millions of dollars, and she was no longer a baby billionaire because everything went to the surviving son, according to the original will, or surviving son's family. So that was a mess. That was a will contest. An oral will is no good, right? Yeah, and it was 88 million, sorry, not a billion. So another mistake we can make in a will contest would be selecting the wrong person to handle things on your behalf. Now, Jerry Garcia did a great job of handling a large part of his estate. One of his mistakes was he had his third wife paying the alimony of the second wife. A little problem. And then there was a problem with his guitars. There was a fight by the maker of the guitars versus Grateful Dead Productions and who would get that property. And yeah, if he had itemized his stuff, you know, people fight over rings, or nobody wants china anymore, but they used to fight over china, but jewelry or guitars. We need to itemize our stuff sometimes. So Robin Williams, he didn't itemize his stuff. He had things planned out really well. He had a blended family, but he did a good job making sure that his new wife had access to the family home for as long as she needed it. But he had a lot of goodies, right? He had won awards, so he had a lot of personal items. Probably had those suspenders from Mork and Mindy, but he had a lot of stuff that he collected that were all collector's items. He just didn't put that stuff together in a way that the family knew where they should go. And so the battle in this case was over the stuff. Once again, they were fighting over the stuff, the photographs, memorabilia. The house was great, but the personal items was what was really wanted in that case. Brooke Astor. She was 105 and worth over $100 million. She looks with it, right? What happened was a couple years, I guess, before she passed away, she signed a codicil to a will. A codicil is an amendment, right? And she changed the terms of her will in this new document. Well, the whole question was, did she know what she was doing? Did she have the capacity or the ability to understand this change she was making? Well, turns out that codicil or the new will was challenged, and everything went to the New York City parks. So she gave her money to charity and to parks and nature foundations in New York City. So nice. Lisa Marie. In this case, the plan may or may not have changed prior to her passing, right? She was in charge of her father, Elvis's entire estate, the Graceland name and all the Elvis royalties. So she had a position of great power and income from being in charge of this entire estate. And she changed the successor from her mom, Priscilla, to her daughter, Riley. And I don't think it has been resolved completely, but it looks like Riley, her daughter, is now in charge of the entire Elvis fortune, which is interesting.
How old is Riley?
She's young. I don't know the exact term. In the 20s. Yeah. Yeah, she's young.
She got it all.
She got it all. Yeah.
I don't think she's 30 because she died.
Yeah, but Riley, yeah. Riley Keough was actually just in a movie. I can't remember that. Oh, Daisy Jones and the Six. I heard it was good. Yeah, I read the book. So, Joan Rivers, can we talk? Well, what do you think she did wrong? Nothing. She did it right. She actually had so many amendments to her will and trust as her life continued, as her life changed. She kept up with it. She did the right thing. She kept up with making those changes as they were needed, and it worked out so well. We don't know what happened. We don't know who got what. You know, her family, and a lot was left to nieces and so forth, but we don't know the details because it was private. It did not end up in a will contest, public for all of us to hear. Private family matter. Gene Wilder. This is kind of interesting. He never had his own biological children, but had adopted a daughter who he then lost contact with. So he didn't have contact with her for years. Well, there were rumors that she was trying to claim, because she was the only, an adopted child is considered a biological child, the same rights that a biological child would have. We don't know what happened because he did everything right. His documents were airtight. He made the changes necessary as life continued, And he did it well enough that we really don't know what happened, but we do know that whatever fight she tried was headed off at the get-go, because an airtight plan seals it. And Ruth Bader Ginsburg, well, thank goodness hers was done correctly as well, because the Supreme Court justice, you want to make sure, knew what they were doing. But once again, everything was done exactly as they should have been done. Everything was held in trust. There was one potential question. She had left quite a large sum of money to a housekeeper of hers. And so normally that question is, how did this person who's not a family member end up receiving a large chunk of money? But because everything was done exactly as it should have been done, and there was no ulterior motive, she actually cared for this person, and with her right abilities, she was able to make sure that this woman received what she was being given. So those are some celebrity horror stories. I could really have added many, many more, but I want to get to, how do we avoid a probate nightmare? So the lessons that we will learn from some of these nightmares are that if the plans are updated, right, as life changes, and if there's a death in the family or a birth in the family or a divorce in the family, you want to make sure that your plan is updated to reflect that change. And all these celebrities, if they had, the ones with the nightmares, if they had sought an attorney to guide them or finish their plans, those personal items from Robin Williams or Jerry Garcia, if you have everything organized and laid out, you avoid that nightmare. For those of us who aren't rich and famous, what can we do? Well, if you don't plan at all, that's when things are just left to that large intestate chart, and they can go to someone that you may have lost contact with or someone that you wouldn't want to receive anything. If your documents aren't finalized, if they're not notarized and witnessed and with the correct affidavits and tied up in a nice neat bow, and if your documents haven't been updated, there are three promises I have for you in life, right? Death, taxes, and change, right? Life is going to change. So you have to make sure that you can pivot with those changes. As our tax laws change, as your life changes, you need to make sure that things are updated so that change doesn't force your family into a situation you don't want them to deal with. So we have a lot of contingency plans when we create an estate plan, right? Contingent, because we just don't know what's going to happen. We don't know if we're going to have a grandchild with a learning disability. We do not know. So we plan for everything in advance and just keep our fingers crossed that everything turns out fine. So another way to avoid property or probate is how we hold our property and transfer our assets. So you don't always need an expensive estate plan to avoid probate. So if you own property, like a home with someone else with a survivorship or a tenancy by the entirety, that piece of property should avoid probate. If you have a beneficiary, is the payable in death beneficiary to a bank account or to another account, that should avoid probate. And if you transfer some assets into a trust, which would hold those assets and then avoid probate. So you want to, Florida is a great state to hold our assets in a way to avoid probate. A lot of my clients have family members from New York, New Jersey, and other states where you can't avoid probate as easily as you can here. So we do make it easy for my clients. I say range from the Uber drivers to the uber wealthy. And I've had clients who've had just little checking accounts, no property, homes, or IRAs or anything of substance, but still knew, this one gentleman in particular, he knew he wanted his nieces to get his bank accounts, and planning for that was beautiful that he dealt with that. So, what do we do when someone calls and sometimes we have clients call us on Monday morning saying that their mom passed away the day before. So, what should we do? Can we sell the house now? Like, well, okay, take a deep breath, grieve. And we do meet with family members. The best news I have when I do have a client that has passed is when the family member hears that they have nothing that they have to worry about, that everything is done, that there is no probate, and they don't have any continuing legal concern. But understanding family dynamics and family history and sort of figuring out how mom kept things or how dad kept things, you don't want to keep everything in folders and files and envelopes where your loved ones get paper cuts trying to figure out what your wishes are too, right? You need things to be accessible and easily understood. And so we try to figure out what to do. We look to see what estate planning documents have been created, if they even exist. Is there a will? Is the will valid? Was it a do-it-yourself will, or was it done correctly? And was the person that passed away, who we call a decedent, that's a legal term for someone who's passed away, a decedent, how they held their assets and whether they were beneficiary of anyone else's assets. I've unfortunately seen where parents and children pass away close to each other, and we've had to probate both estates in order to have assets distributed. So you want to make sure that things are just kept in a way where you also have alternates. If you have a bank account and you have one beneficiary, put a second beneficiary as a contingent beneficiary just in case. So that way, if your first beneficiary passes, that asset does go to somebody else. You can always change beneficiaries. And then if you have a family change, beneficiary change, an asset change, a change in the law, or any trust changes, that's when you need to update your plans. Yes? If the beneficiary is out of the country, we have to look to see what the laws are of that country and what agreement this country, the United States, and the other country have with regard to the taxes. So though that changes quite often, and it's country by country where that would go. Yes?
Do you think there's assets in another country?
Yeah. So unfortunately, many people do have assets in another country, and what we do here can guide another country's decision makers, but we can't force the hand of another country to follow our rules. So you always need to communicate with someone in that other country to make sure that you have your assets passing as you would want them to pass. Let me tell you two quick things. Retirement assets. A lot of people don't know this. There's something called the Secure Act, which was passed a number of years ago, which changed how our families inherit our retirement accounts. So this doesn't change for spouses, but if you have a child who is not yet retirement age and they inherit your retirement account benefits, it's no longer stretched over their actuarial life value. They can't stretch it out. It's either 5 or 10 years, depending upon how it is held. And there could be quite a large penalty potentially imposed if they take it all at once when they're too young to inherit.
Would they be able to roll it into their own?
Possibly no. No. They used to be, right. It's a real messy new law. And so we're already on Secure Act 2.0, and it's only been like 5 years since it was enacted. So it was enacted on, I think it was December 23rd, 2019. I think that sounds correct. So December 24th, I was messaging all my clients. And guess what? We need to meet next week and figure things out. Yes.
Those assets in a retirement account go into the trust.
Maybe yes, maybe no. Depending upon who they are directed towards. I do like for them, for many circumstances, to go into a trust. It has to be done with the correct language. There are separate retirement account trusts, but even if they go into a trust, there could be some issues. So if you have retirement accounts, make sure they're directed appropriately. Yeah, and a financial advisor should be able to help you, right? A financial advisor can help. You don't need a lawyer to tell you that. A financial advisor or an accountant can help you. But poor planning is expensive. It really can be. And the cost is to your loved ones because they're the ones who have to pay the price. We also live in a digital age. We live in an age where we have a lot of our information on phones or computers. And if, let's say, you're incapacitated, you're out of it, you can't communicate, and you're in the hospital, and your loved one takes your phone to a store to have information retrieved, they have to have the right documents allowing them access to that digital device. So we go into in depth our digital assets and digital devices, our stuff, our equipment, and also Amazon passwords, right? Because sure enough, there's going to be some predator who can steal an old lady's Amazon.com account and start charging up a whole lot of stuff. So we also look at social media accounts, and this is changing constantly. The laws are constantly evolving. So reality, 70% of people in this country do not have an estate plan. I'm not going to embarrass anyone, but does anyone want to say if they do or do not have an estate plan? Anyone not have an estate plan? Yep. So I hear quite often, well, I don't know who to pick as a guardian, right? Or everything goes to my wife. Everyone knows that. Or my kids will get it. Or everyone knows where things are going to go. I don't need it in writing because they know who's getting it. That's not the case. So things don't pass according to what you believe they pass, because many people think it just goes to your spouse and it doesn't, or they think it's just going to go to their kids and it doesn't. So summary, that's not me. I think it's Tina Fey, I'm not sure, but find an attorney if you haven't to help you, or just make sure your plan is updated, and that if you do have questions, ask the questions, because the worst thing that could happen is that your family's left sort of in the dust without having the plan that they need in place. So this is my firm. I can answer some more questions. I don't want to have any questions that are fact specific because I can't give you legal advice like this, but I can answer some other questions. Anyone?
And we also had a question online, if you don't mind.
Oh, sure. Okay. Is a will required for things like 401k and ESOP that already have disbursement information put on them? Not necessarily is the answer. But a will is required for other things. So if you do have beneficiaries on accounts, great. But some of you have the handouts in front of you. Quite often, in fact, yesterday I had clients come in and they had probably put together close to like 1.2 million with their home was maybe worth like 600,000 at the prices that they have today, and a couple of investment accounts. One had an inheritance, and they had a 14-year-old son. And they said, well, he's just our beneficiary on everything. I said, great. So when he's 24, is he going to get 1.2 million if something happens to both of you and go to Vegas? Right? How do we protect our loved ones during a time in their lives where they may do silly, stupid things? So having a beneficiary on an account, if they are not mature enough to handle the funds, that's when we need to protect them, because 25-year-olds are not like 25-year-olds in our day, right? They do not have the understanding of what it takes to live the rest of their lives and what they've got. And a couple 100,000 can be gone very, very quickly. So, yes.
I know every family is probably different circumstances and depending on your assets and what you have, but how do you figure out what something like this costs? Like, is it calculated like per hour?
On an estate plan?
Yeah.
So some attorneys charge by hour. I think that's ridiculous. I charge a flat fee. And so we talk for about a half an hour. I have a bunch of questions because since everyone's different, I need to ask certain questions to figure out if we're a blended family or their businesses, homes, we have property in other states or in other countries. And then I always quote a flat fee that I'm in Davie. I used to be in a fancy building off Las Olas. I charged a lot more when I was in the fancy building, but that was over 11 years ago. So I've been in Davie for 11 years in my current office. And so I'm able to play more with my numbers.
You spoke about the power of attorneys before. In my instance with my mom, you had to have two. You had to have the estate power of attorney, and then you had to have a health power. That's still the same?
So
You have to have two different ones?
well, okay, so let me back up a little bit, because for healthcare, we have a healthcare surrogate, someone to make healthcare decisions for us. And I always like to have alternates, because your surrogate may be with you in that car on 95, right? So you want to make sure that you have the next person in place to take that call. For a power of attorney, a financial power of attorney, that's during your lifetime, that ends at the end of your life. So for an estate, which is after you're gone, you have a personal representative or a testator. Now, these can all be the same person. You don't have to have two, but they're different documents that we're talking about. Anyone else? Was this good? Was this helpful? Interesting? Well, I thank you all for letting me be here. And one more question? Yes.
If you have bank accounts and you have payable on debt
Mm-hmm.
to whomever,
Mm-hmm.
does that money get taxed to them?
It's a great question. Do they have 12.092 million?
Not that I know.
So there are a number of different types of taxes, right? So if you own a home that you bought at 100,000 and then it's worth $1 million when you die, if that's held in a revocable living trust, let's say, your family gets the stepped up basis. So they don't have to pay capital gains. So they're not paying from 100 to 1 million, that capital gains. But do they live in a state that is going to tax that as income? They may, right? So there are different types of taxes that we talk about.
Same subject. Does every one of your bank accounts have to have that? Yes. Or is it beneficiary sufficient?
So let's say you have 4 accounts with SunTrust, and they all have beneficiaries. SunTrust became Truist a couple years ago, or sold to Truist. They lost a bunch of beneficiaries, we found out. So you want to make sure for every account that you have, and I always say a good rule of thumb is when you're doing your annual taxes in April or May or whenever you get around to it, make sure that every account has a beneficiary listed. That's a good time of year to make sure everyone is still there, because Truist lost beneficiaries from SunTrust and BB&T. Years ago, it was Wachovia to Wells Fargo. They lost beneficiaries. And more recently, Merrill Lynch lost some beneficiaries. So always make sure that you have those beneficiaries intact. So thank you all for having me.
Thank you so much, Andrea. Wow. That's a lot. That's a lot of stuff, right? So we might be able to share the presentation just to get some more thoughts.
Yes.
And also, I'm going to send you a survey so you can fill out to so we know what your responses are and maybe get some more questions from that. So this is a first time we've ever done this, and I just want to let you know that Andrea was recommended to me by my estate plan attorney who retired, and he knew that she had a heart for community service, and she didn't charge to come here today, which a lot of speakers do. So we really want to extra thank her. She did this free of charge. So thank you. Thank you. And so please, I encourage you to keep looking at the subject and contact Andrea or her office if you have any questions. And thank you all those of you who are online. We had about 21 people online. So feel free to reach out to me if you have any other questions and you have Andrea's information online. Thank you, everybody.
Thank you.